Thank you all so much for being here. For those I do not know, my name is Jennifer Collins, and I am the Dean of this wonderful law school. And it is my great privilege to welcome you all to BALSA's annual Black History Month luncheon. This is such an important and meaningful event for our school, and I am profoundly grateful to our wonderful students who, in addition to studying for class and everything else we asked them to do, found the time to put this terrific event together. So thank you so much for all their incredible hard work. We are also very grateful to our speakers. They will be introduced by our students. I'm going to turn the platform over to Michaela Noble. Thank you for all that you have done in particular to bring today together, and we look forward to a wonderful and interesting conversation. Thank you so much.
Thank you again to all of the attorneys, community members, SMU faculty, staff, and students for attending the SMU Black History Month luncheon today. Our goal for this annual luncheon is to address issues specific to the African American legal community, and this year, we will do that with the topic Lawyers Serving Our Communities, a discussion on race, biases, and social interactions. The luncheon aims to foster a sense of inclusiveness by encouraging the legal community as a whole to come together and help alleviate these issues. Our first keynote speaker will be Mr. Justin Moore. Born in Dallas, Texas, Justin Moore is a graduate of Morehouse College and SMU Dedman School of Law. He served as a prosecutor at the Dallas County District Attorney's Office prior to establishing his private practice that focuses on criminal law, civil rights litigation, police brutality cases, sports contract negotiation, and campaign management. Through his practice, he seeks to not only obtain justice for his clients, but he hopes to use each case as a tool to make our justice system equitable and fair for all who may come into contact with it. Outside of his professional endeavors, Justin advocates for mental health awareness, criminal justice reform, and social justice. Please join me in welcoming Mr. Justin Moore.
Wow. I feel like I'm back home. It's been 5 years since I graduated from this school, and I am so blessed and so thankful to be invited back by Michaela and the BALSA organization here. And I want to thank everybody here in attendance. SMU Law family, folks that did not attend school here. Even though we are separated by academic distinction, we are familial when it comes to our pursuit of justice and law. And I have to say, attending a few of these luncheons in the past, as a student and as an alum, I'm aware that there may be some folks here who aren't entirely interested with what I have to say. It might be more interested with the free meal and the time away from the classroom or their office. And I would be hypocritical if I felt in some way offended by that. So please, I get it. Enjoy your time here. Let this lunch serve as a respite from the monotony of your day-to-day activities. With all said, seeing that I am familiar with today's luncheon, I must admit it made my student loan payment these past 2 months feel a bit more enjoyable than usual. Because those aren't really enjoyable at all. Unfortunately, I have an arresting suspicion that that feeling is fleeting. So maybe next month this will all wear off and I'll try to avoid it once again. But I am making my payment, so that's not an issue. Now today I'm here to talk to you about race, biases, and social interactions. I guess that makes my effort here today all the more difficult, I suppose. But I believe these issues have a great meaning given the times that we live in. And given the vocation that most of us in this room are engendered in, it provides us an opportunity to unpack these issues. It also provides us the opportunity to understand the legacy of civil rights work, or cause lawyering, as I like to call it. For the practice of law is based on legacy and precedent, and these two things are rooted in the experiences of the lawyers that came before us. Let us not take for granted the victories of those lawyers who've come before us, because we stand on their shoulders. Oliver Wendell Holmes Jr., the former Supreme Court Justice, understood this better than anyone. He quotes as saying that the life of the law has not been logic, it has been experience. the felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, avowed or unconscious, even the prejudices which judges have shared with their fellow men, have a good deal more to do than the syllogism in determining the rules by which men are governed. The law embodies the story of a nation's development through many centuries, and it cannot be dealt with as if it contained only the axioms and corollaries of a book of mathematics. In order to know what it is, we must know what it has been and what it tends to become. So for just a few moments this afternoon, I want us to explore exactly what has cause lawyering been. Cause lawyering marries community involvement and litigation in a way that isn't seen in other areas of legal practice. And that's what makes the work that we do so important and so relevant to the advancement of underrepresented people. So what exactly is a cause lawyer? A cause lawyer simply is an attorney who advocates alongside social movement. More often than not, cause lawyers are seeking structural and enduring changes that increase the power of those who are most disadvantaged politically, economically, and socially. After a century of movement advocacy and various shifts in public opinion, we are at our most effective when we are able to convey that our position is in line with public opinion and in the interest of justice itself. It is always important when it comes to cause lawyering that we show our clients that success doesn't entirely hinge on a verdict or a settlement. The ability to take part in larger conversations with regard to society and culture is a useful tool and must be used contemporaneously with litigation strategies. Framing each case as a campaign for a larger narrative and critique on our society allows us to use said case as the face for a new movement for reform regarding those issues that are being litigated. So what is the tradition of cause lawyers? Well, for me to devote the appropriate amount of time to explore this tradition, me and Dean Collins would need to probably get lunch after this thing, or coffee rather, and talk about me getting the adjunct professorship so you guys can sign up for it. So Dean Collins, coffee after this, does that work? All right. All right, but since we don't have a lot of time here today, I will try my best to extrapolate what the tradition is by way of example. Although there have been many cause lawyers whose work dealt with the intersection of race and law, one lawyer in one case comes to mind to show how community engagement and litigation are important to the practice. This lawyer is Charles Hamilton Houston, and the case deals with an African American who was charged with murder. Now, who was Charles Hamilton Houston? He was a pioneering black civil rights lawyer who earned the title the man who killed Jim Crow. That's a heck of a title for a lawyer. The case in question actually was his introduction into cause lawyering. This case is important because it was critical in laying the groundwork to bring an end to the exclusion of African Americans from juries across the South. In the fall of 1933, Charles Hamilton Houston walked into a courtroom in Virginia set to defend George Crawford, an African American whom had been charged with murder. This placed the both of them at the center of a very divisive conversation surrounding race in this country. 2 years prior to Houston stepping foot inside of that Southern courtroom, Agnes Ilesley, a wealthy socialite, and her maid were murdered, and it made national headlines. Crawford was immediately identified as a suspect, and he was indicted in an instance. Many people feared that he would be lynched without receiving due process. After a year-long nationwide manhunt, Crawford was apprehended in Boston, Massachusetts, and from there he was taken back south to where he would face trial. During the course of his pretrial odyssey, the NAACP publicized the case and organized widespread support in an attempt to prevent Crawford from being extradited back south to Virginia. Through their efforts in framing the issues in a social justice context, federal judge James A. Lowell, it is safe to say, was moved to the point to rule that it was unconstitutional to extradite Crawford back to Virginia, based on the aspect that African Americans had been excluded from the grand jury that indicted him. This ruling from Judge Lowell aided the movement that was being forged concerning the fairness of Southern justice. Unfortunately for Crawford and Houston, Judge Lowell's order was overturned on appeal, which was a very predictable outcome given the time and the place. This trial became a watershed moment in the social movement for a fair and equitable justice system. It helped elucidate the notions of how race was an integral factor in a region of this country that openly supported disenfranchisement and lynching. Another thing this case highlights is how the NAACP, not the lawyers involved, were not only at the forefront of the social movement outside of the courtroom, but how they influenced the players inside of it. It is well documented how Judge Lowell was swayed by the NAACP, framing this case as a campaign for equity on juries. But what is not discussed, however, is how the NAACP made the decision to use Charles Hamilton Houston as their lead counsel. This was the first time a black attorney was used by the NAACP to litigate a case for them. It was always suspected that a white attorney would project better to all white juries, and that a black man would not fare so well. Now, I know as a fellow lawyer, it is easy to inflate our importance in society. But what this shows is that with the history of cause lawyering, we did not lead these movements of social change. Sometimes we were just merely used as props. Social discourse, it seemed, was framed by those who did not hold bar cards. Even the decision about who would try these cases were determined by those who would have never tried a case. This is interesting because this wasn't the only instance of its kind where legal engineering by attorneys wasn't enough to ensure a particular outcome. Now, I know the hubris that exists in our profession would not lead us to believe this, but the point has been well studied. Legal scholars who have devoted time to studying the effects of social movements generally have deduced that significant change rarely results from litigation alone. Social movements are most effective when members advocate both in the courtroom and on the streets, as change is best realized when the general public understands and supports a position. This point is exemplified even more with the sine qua non of contemporary American social movements. The Montgomery bus boycott demonstrates the effectiveness of community mobilization and how important it is for achieving change. If we recall the Montgomery bus boycott, Martin Luther King Jr. helped organize a carpool that could transport African Americans to work during the city bus boycott. Locals in Montgomery participated in peaceful protests while attorneys fought for the movement inside the courts. And ultimately, in 1956, the U.S. Supreme Court declared bus segregation illegal. Even though the Supreme Court gave a favorable ruling, civil rights advocates still feared that buses would not effectively desegregate without continued advocacy locally. And to be honest, they had cause for concern. You see, despite the ruling in Brown v. Board of Education, which held that school segregation was illegal, schools, in fact, were still segregated in some parts of the country, namely the South. And bus desegregation, that ruling was rendered shortly thereafter. So if schools weren't desegregated yet, we know that buses weren't. Now, it's easy to see in this situation that litigation would not be the solve to cure this problem. Direct action of social movement members themselves was required. The legacy that the Montgomery bus boycott has left us is that the meticulously organized nonviolent movement proved that social movements in general could demand and obtain relief from degrading treatment outside of the courts. Now, let us not discount the work of our forebears. Prior to the Supreme Court ruling, the citizens of Montgomery were unable to gain any traction at all. The Supreme Court ruling got the ball rolling. But it's also important to note that while the ruling was determinate, it did not present any implementation guidelines for desegregation. Organizers of the movement were needed to create measures to ensure that desegregation was enacted. If the two parts of the movement, lawyers and organizers, would have worked in separate silos, there would not have been any tangible results in Montgomery. But the two groups working together achieved one of the biggest civil rights victories in this country. It is this example of working together with the community which is being hotly contested behind the scenes today. Whenever there is a police-involved shooting or a racially motivated crime being investigated, we tend to see this debate rear its head. Is it proper to involve the public in these matters, or is it proper to let our public officials deal with these matters behind closed doors? For one, as history provides us insight, The effectiveness of bringing legal issues to the streets has its advantages. Aligning causes with social movements provides folks who traditionally have been disenfranchised and their voices who traditionally have been marginalized an amplified platform and increased negotiating power. On the other hand, publicizing a contended, highly polarizing issue before it has been settled in the court has been seen as divisive and dangerous. How are we supposed to dispense with such a dichotomy? We live in a society where information is shared at a high speed, and our interconnectedness is woven together by the single thread of social media. The mention of an incident can be shared before we even know the facts. There is inherent danger in this. Getting the public on the side of the most persuasive rendition of what happened can generate rabid emotion. Therefore, narrative crafting has been a highly used tool because of this reality. Whenever there is something like a police shooting, there is a race by competing parties, whether it be the attorneys for the victim or the PR arms of the police departments or the PR arms of the district attorney's offices to create a narrative that would be favorable for each. Far often than not, this is the intersection where you see race, bias, and community converge. As far as race and community is concerned, our legal tradition tells us that we cannot divorce this from ourselves. This nation was founded on race. Its invention has been used to distinguish the have and the have-nots. Its invention has been used to create theories of who is human and who isn't. Throughout our history here in America, there has been one group who has always had this legal distinction, and there is another group who has always fought for the full legal distinction of who is human. This is our legacy, and the courts have not been inculcated from this legacy either. In fact, the courts were where discussions about race took place. It is also where the public always watched intently to determine what their marching orders were accordingly. Whenever there is a case that touches the distinction on who is human and who isn't, the public has always shown an interest in the answer. And most often than not, a shrewd lawyer would always make notice of this interest. One shrewd lawyer, by example, and I like examples, so bear with me, was Raymond Alexander, an early 20th century African-American lawyer from Philadelphia, like my friend Lee. Well, no, he's really from LA, but who was another pioneer in obtaining civil rights for African Americans. He was defending a black defendant by the name of Willie Brown against charges for the murder of a white woman, Dorothy Lutz. The trial was fraught with a highly racialized imagery that showed Brown as a rabid, highly sexualized, aggressive criminal. These were standard tropes for characterizing a black man then, and unfortunately you see those tropes rear their head now in some instances. So his hyper-criminalized image was juxtaposed by this angelic image by the victim, Dorothy Lutz. It also didn't help matters that the case was assigned to a judge who was known as a loyal champion of police against all complainers. And he was a scourge of violent criminals. Ooh. By all accounts, this was a high-profile case. It played out in front of an interracial audience of unseen proportions. And the profile was amplified by the perceptive theories that were provided by folks who opined that Brown's prosecution was motivated by race. Theories that incensed the prosecutor and the trial judge. White news outlets and black news outlets throughout Pennsylvania alike covered this case. It didn't help matters that many African Americans were appalled when rumors circulated that police, lacking suspects and needing a scapegoat to keep public outrage down, randomly picked up Brown and coerced his confession by beating, starving, depriving him of sleep, and threatening him that he would be thrown away to a lynch mob. The felt realities of this case for Raymond Alexander was that he was faced with a judge who was pro-police and anti-victim, and a prosecutor who employed tactics to use the stereotypical depictions of a black man to criminalize Brown further. When Brown's murder trial opened, Alexander was catapulted into a courtroom that was not favorable for a black lawyer. He was looking at a difficult audience, one that consisted of a hostile judge and an all-white jury that he suspected all black potential jurors were struck from. All of Alexander's charges of police brutality to coerce a confession were a tough sell. This trial was tough. Appealing to perfectly crafted legal arguments alone would not work. He needed to appeal to something outside of the courtroom, and in his closing arguments, he did just that. Faced with the specter of Willie Brown's death, he reminded the jurors that 219,000 colored people in Philadelphia were awaiting this verdict. And they were. This case mattered to the black population in Philly because this was something that could have happened to any one of them. Being picked up at random and tortured into a confession. This was horrific. Unfortunately for Alexander, he lost this case at trial, but ultimately he went on appeal. However, his closing argument resonated, and it still resonates today. Each case that involves how race is policed in America is watched intently by those of that race. It is something that we cannot escape from. Every time there is a victim of police brutality, which disproportionately involves a person of color, it strikes fear in other people of color. This is something that can happen to either one of us. It is important for the psyche of minorities in this country to see justice being served for the victims because it provides a gesture from the justice system that says, hey, your lives matter also, and we will protect you from violence like we protect everyone else. The spirit of Willie Brown's case and how Raymond Alexander invoked the watchful eye of African Americans resonates in the work that I do. In a recent police brutality case I was involved in, this idea shines through. This case involved a man who was sitting in his own car, kind of dilly-dallying, doing his own thing. A witness saw him there while his alarm was going off, which was triggered inadvertently, and he called the police on him. As soon as the officer arrived at the scene, no questions were asked. Immediately, he began to assault my client. And ultimately, as my client pleaded with him not to shoot, he ended up shooting him 3 times, twice in the back, once in the stomach, all the while saying, don't shoot. See, this was the reality of that story. But however, the police crafted a story that was completely different from what actually happened. Their telling of the story was of a man who was trying to break into cars. Ultimately, that did not hold water. Secondly, they used this story, they concocted the story of a man who was trying to evade arrest by the police. That story did not hold water either. Luckily enough, the general public had not caught on to the case yet. What had been reported, nobody knew of. It was effectively being swept under the rug, and the officer wasn't even being investigated at that moment. The task we were faced with was, 1, to get answers for our client. He needed to know why he was shot. 2, figure out what his charge was. He essentially was being held, detained, chained to a bed in a hospital, not facing any charges. How cruel and humane is that? And 3, we needed to have the officer who attempted to murder this man reprimanded, fired from the force, and face charges himself. The problem here was that we received absolutely no cooperation from law enforcement. I was denied access to my client. I was escorted out of the hospital where he was staying, and I was banned from seeing him under the threat of arrest for attempting to stop an unlawful interrogation. The DA's office would not consent to letting us view body cam and dash cam footage at our request, and the police department would not correspond with us at any moment. The attempt to use the appropriate channels had been made. However, the factors at play served as impediments towards getting answers. One of these factors was the criminalization of our client, a black man who was seen by a white witness as attempting to steal his own car. 2 was the fact that once the authorities realized the officer's justification for applying deadly force was rooted in bias and not reality, they stalled for time in an attempt to concoct another justification to have applied deadly force. 3 was that in furtherance of this stalling for time, communication between the victim and the authorities was non-existent. We sensed the cover-up, and it was fueled by law enforcement pushing against the bounds of race and ethnicity in the media by attempting to criminalize our client further. Our only recourse was to take this case to the community. While law enforcement agencies involved were comfortable with the false narrative of a black man being shot while committing a crime, we were not. Our appeal to the public was immediate, and it was through social media. It was a 5-week journey from incident to indictment. It was full of drumming up support through social media, getting the public engaged, enlisting a social movement around our client that involved a fundraising platform, an interfaith coalition, speaking at churches, rallies, and a host of press conferences. We tasked the community to show their influence with our elected officials and have the true culprit of the crime face charges for his acts. It worked. It worked because we detailed the influences of bias and race that were at play in the investigation of this incident. It truly struck a chord, I believe. This is the value in not being afraid to remove the veil and show how race and bias is used in our criminal justice system. Because these cases do not exist in a vacuum. This is a dangerous reality for people of color, and this is what we live with every day. To be identified almost randomly as a criminal suspect and have deadly force applied is terrifying. And to have all of this happen and then to have a subsequent attempt at a cover-up is even more jarring. The community sees the value in knowing the details of this case, and we as attorneys need to acknowledge the value in making sure the community is well informed of the intricacies of how justice is applied. Now, it is easy for us as attorneys to practice on an island, divorced from this reality that the public has a vested interest in our work behind the scenes. But our cases are important to show the realities of a society that tends to be cosmetically modified. We know that far too often situations that involve race and justice get swept under the rug. And I have to say, working in this field makes efforts to foster racial harmony that more tenuous. Sometimes I think to myself that this job is pointless, and I think that this is a road to nowhere. But each time these cases get exposure, and each time a victim gets justice, I begin to see a light at the end of the tunnel. I understand that cause lawyering, which necessitates community engagement, is something that a wide swath in our profession may turn their noses up at. And to be honest, I have my reservations as well. But to practice in such a manner where you don't feel the need to alert the public of the ills of the criminal justice system would be morally wrong. We don't have time to stay comfortable in our hollow courtrooms and classrooms. It is important that we let our fellow citizens in on the inner workings of justice in our society so they can equip themselves with the context in which they live in. We all are lovers of history here, I presume, because as mentioned earlier, this is a profession that has a symbiotic relationship with precedent. Experience is our legacy. It is our experience that we have achieved social change that embodies justice being applied with equanimity through active community engagement. American lawyers hail from a legacy and lineage of immeasurably strong people, folks who were adroit in the courtroom, but who also had strong ties in the community. We stand on the shoulders of Charles Hamilton Houston and Thurgood Marshall and Raymond Pace Alexander and Sadie Alexander and Lauren Miller and Polly Murray. These cause lawyers were many things to their clients in the bar associations they were members to, and they knew the role that racism, bias, and community played in their professional lives as well as their private lives. When it came time to advocate for the betterment of their clients, their race, and their country, they did not let pretentiousness get in the way. If you have ever dealt with work in this field, you have come across a case or a client that made you feel just as helpless as the client feels. You were pushed to your wits' end because you were unable to find recourse for your client through the appropriate channels. You had this notion that this case could only matter to you and the client, and no one else would truly care. Well, I assure you, if you are able to frame your case in a way that resonates beyond the singular and extend its implications to the community as a whole, your voice will be amplified and you will be able to generate the influence necessary to not only get the results you seek, but to generate social change. And when I talk about extending implications to the community, I'm talking about getting them involved in each step of the process of obtaining justice for your client. One of the current cases I'm working on exemplifies this maxim perfectly. I'm going to tell you about a young couple outside of San Antonio. They were looking for homes to raise their young family in. And as they were in this neighborhood that they drove by and they had been seeing for a few months, they stopped by a house that was still under construction. With the husband being a construction worker himself, he figured the house was safe enough to bring his young wife to take a look at the backyard, to see if it comported to their values and the size that they needed for their young daughter and the dog that they had. As they were in the back looking at the backyard, they heard a loud crash. It sounded like glass was breaking. As they peered around the corner to see what was going on, they saw a woman busting their windows out with a piece of concrete slab. And as they approached this woman, she began yelling racial epithets, saying that they didn't belong in this neighborhood, that they would never be able to afford the houses in this neighborhood. It was very, very terrifying for them. So, like everybody does, they called the police. They called the local law enforcement. An officer arrived at the scene. He took a look at the car. He interviewed both the victim and the suspect, but he did not make any arrests that day, although there was evidence of a crime and there was a victim there to corroborate who did it. And it took them an entire month until they contacted me. And throughout that entire month, nothing had happened at that time. No arrests had been made. Countless appeals to the sheriff's department there, the police department there. Nothing was being forged forward as far as an arrest being made. And when I was contacted, it was settled that local authorities did not find any interest in seeking justice for this family, and it was presumed that race was a factor. As soon as I got this case, I made an appeal to the locals in the community there. And within a matter of days, the public outrage generated an outcome where the culprit is now facing a felony charge. It took nearly a month and a half for this family to begin realizing that they will receive justice for this crime of hate. In this scenario, I had no real means of helping the family. I wasn't a part of the San Antonio bar. This case was being investigated by the local authorities. I was really just an outside bystander with no real weight. But using my position as a lawyer and how we are perceived by the public, we enlisted a campaign of involving the locals in the community there. And that was the only way that my appeals to local law enforcement would not fall on deaf ears. This campaign was fueled by social media and carefully worded press releases and Facebook posts that not only detailed the issue but explained its larger importance to the community. Like Raymond Pace Alexander said in his closing arguments defending Willie Brown, a multitude of African Americans and Hispanics were watching to see how the state of Texas prosecuted hate crimes in this state. And today the suspect has been apprehended. It really took like 4 weeks after she was charged, which is another issue, but I'm not going to detail that today. And now they're on the path towards getting restitution and justice. This is an example of why community engagement is vital when dealing with the issues of race and bias. When you believe a case or an issue is being suffocated by perceived bias, take your appeal to the public. Public outrage, when used responsibly, can provide you the result that would have occurred if race and bias weren't a factor in our criminal justice system. With my time here spent as a student, I studied under the tutelage of professors who taught us how the Constitution provided us equal protection under the law and expressed to us the parameters with which state actors can act in. Shout out to Professor Khan. Is he still on sabbatical?
Still in Norway.
Oh, okay, there we go. But I wish these axioms were self-correcting and didn't need ancillary forces to bend our country's moral arc towards justice. But we can't rely on what we wish would happen. We must be vigilant in making justice happen for everyone. It's hard, and it will involve going outside of the conventional modes of legal practice, but the betterment of society depends on us not giving in to pretentiousness. We must use any means to highlight injustices being committed. If we fail at making our communities better as lawyers, then we have bastardized this vocation. I know that when I retire someday, I will not be thinking about any accolades I may accumulate. I will not be thinking about the SMU luncheon that I keynoted. I will not be thinking about how much money I made. I will measure my career by how I helped my community, my race, and my country move forward. I'll be thinking about how I helped progress race relations in this country. And finally, as we realize that our profession's legacy is based on the intersection of race, bias, and community engagement, we must move forward to ensure that we embolden the modes with which how this troika is dealt with progressively. We must set our heights higher than just the case in front of us, or even how it affects the local community. Cases within this realm of law have served as the faces for campaigns that would go on to affect legislation. Therefore, America has a vested interest in each of these cases. Our mission going forward should be to preserve how we engage our communities. We are faced with not only a perceived dissatisfaction towards cause lawyers who take their appeals for justice to the community, but we have seen policies implemented that have the ability to mute our voice and block the free flow of information to community folks who have a vested interest in our cases. We live in a society where the current administration's repeal of net neutrality serves as an impediment of community involvement to achieve justice for marginalized people. With her dissenting opinion regarding net neutrality, U.S. Congresswoman Manon Clyburn stated that particularly damning is what the repeal will mean to marginalized groups like communities of color that rely on platforms like the internet to communicate because traditional outlets do not consider their issues or concerns worthy of any coverage. It was through social media that the world first heard of Ferguson because legacy news outlets did not consider it important until the hashtag started trending. It has been through the secure messaging platforms where activists have communicated and organized for justice without gatekeepers with differing opinions blocking them. So our training as lawyers and the legacy from whence we practice gives us special insight that our society needs. We know that our legacy involves the free flow of communication to the public. Community engagement is vital. It is radiated by our First Amendment privileges. If we tap into this experience, it should endow us with perspective and understanding, the understanding that the inability to send out a clarion call at a moment's notice of an injustice is prohibitive of not only progressing our society forward, but from us having a free-flowing ability to practice law. It should give us a sense of knowing that these issues affect us all, no matter who we are, how much money we make, or what academic distinctions we have. The ability to speak freely about social injustice is an ability that needs to be preserved. It should give you a sense that silencing one of us is, in fact, silencing all of us. And I will tell you, SMU, whatever success in my practice I will achieve going forward, it will not be due solely to my own efforts. It will be due to my deep connection with the community. The willingness to involve folks outside of this profession in my work is something that has provided me meaning that I have never detected before. The weight with which I approach issues is heavy, I admit, but that's how it's supposed to be. Our work does not exist in a vacuum. We are heirs to a great legacy of community engagement. We must march forward and not abandon this legacy. If we divorce ourselves from experience and revert back to the cold logic of syllogism that Oliver Wendell Holmes Jr. talked about, we would be doing a disservice to our fellow countrymen. That is all I have today. Thank you so much for the opportunity.